Magistrate Code Enforcement meeting for the City of St. Pete Beach for Monday, August 10th, 2026. Hello, my name is Erica Agello, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida Statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today. I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order in which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy. So please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in anyone wishing to speak today. If you intend on speaking, please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Okay, so sworn. Any changes to the agenda this morning, Mr. Dewar?
Good morning, Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. Changes to the agenda, new case 4B, 2026-0197. We'd like that case to continue to Special Magistrate agenda, September Special Magistrate agenda.
Okay, so that meeting is scheduled for September 14th.
September 14th. Yes, please. Thank you.
And I'll get you an order to that effect.
Thank you.
Other changes to the agenda?
No, ma'am.
Okay, then moving right along, we'll go to agenda item 3A, case number 2026-0138, City of St. Pete Beach versus Timothy Wheeler and the estate of William J. Dudley.
Good morning, Special Magistrate. Case number 2026-0138. This is a status for work being done without a permit. And I'm gonna ask for Mr. Chris, building official, to come up and speak about it.
Okay. Mr. Curtis?
I'm sorry, Mr. Luke.
Yep.
So, my apologies, I wasn't quite set up yet. Bear with me 2 seconds. So for this property, it was built in 1984. It is a post-firm structure that should not have habitable living area on the ground floor. And the property records show through Pinellas County Property Appraiser that it is for storage, parking, and building access only. At some point in history, it was converted to living space, and there's no permitting record for that. And that is the basis for, between Florida Building Code and our city code, does not allow for living space on that ground floor, and as such should be removed. That's pretty much the extent of it, but I'm open to answer any questions if there are any.
Okay, so I think that was the same testimony that you gave at the last hearing, and my understanding was that the property owner was going to work with city staff to figure out if this was perhaps, or the property owner's representative, perhaps a non-conforming, legally non-conforming use, but you're saying there's still no record of any permitting. Does the city have any permitting records from that time period over the last 40-plus years?
Yeah, we do have permit records. And I'm just double checking this. Correct. Bear with me. Oh, thanks. Oh. Sorry, bear with me a moment. So, my apologies. So there is in our records a variance that was done for the property back in 1983, which allowed for a bathroom and a utility room. And the transcript from that variance, the it says there would be only a garage, utility room, and bathroom. Somebody asked if there were plans to make this area into an apartment, and the respondent said no. So there was a variance for the bathroom and the utility room, but it was clear that it wasn't going to be used as an apartment, a living area.
Okay, and so in order to come into compliance, they could continue to have, the property owner could continue to have the utility room, the bathroom, but it would have to function as a garage.
Correct. Garage, storage.
Okay, and so is there any indication that there was allowed to have air conditioning or other types of things that are not typically allowed on a first floor?
And there's no comment to the air conditioning.
Okay.
From my perspective and from the code that's in place with the Florida Building Code and for the city code, the air conditioning wouldn't necessarily be a restriction or define it as living space.
Okay.
So, for example, somebody might just want to control the moisture in that area. So if somebody wanted to put AC in there, I wouldn't necessarily say no, but the parts that make it a residence, like a kitchen or other separated areas, that might point towards a living space as opposed to just storage or garage space.
Okay, so for this particular property, in order to come into compliance, and I haven't heard from the respondent yet, but in order to come into compliance pursuant to your records, they could keep the bathroom, but they would have to remove the kitchen. I believe there's a kitchen on that first floor. They would have to remove the kitchen. Do they have to move any electrical or cap any electrical or plumbing in order to combat the habitable living space definition pursuant to the Florida Building Code or the city's code?
There wouldn't be a restriction to not have the electrical, but any electrical below design flood elevation would have to comply with those regulations. So for example, in the National Electric Code, it requires anything below that design flood elevation to be designed for wet location. So it depends upon the materials used, they might have to alter that, or they could raise up receptacles that aren't designed for a wet location up above design flood.
But they would only be required to do so to the standards set forth in 1983, to which the variance allowed them to have the bathroom and have a utility room, correct?
Correct.
Okay. All right. Thank you, Mr. Curtis. I appreciate your testimony today. Anything else, Ms. Knight?
No, Special Magistrate.
Okay. Anyone here on behalf of the property owner? Okay, Mr. Disbrow, what do you have for me?
The property was purchased 23 years ago. It's been functioning the way it's been functioning the whole time, and just confused why this suddenly has become an issue.
Okay, and so understanding that it was purchased 23 years ago, does the property owner have any permitting that, and I understand the property owners purchased it subject to the first floor already being
Correct.
renovated.
Yeah.
Of course, that would have been, it could have been illegally renovated prior to purchase, and that's a risk that you have to take unless you're doing any type of inspection or
Yeah.
whatnot. So you don't have any records to solidify that
There was no reason to, right? When you buy it,
at the time.
considering
Well,
it.
yeah, understood. Understood. Okay. And at this time, so all I have to go by is the city's records that say there was a variance for a utility room, and I understand that the property owner's been using it in this fashion for 20 years. I will say when something comes to light, the city has a right to enforce its code unless you can produce evidence that supports it was otherwise allowed. It's still technically illegal. So,
Yeah.
okay. Anything else from the city?
No.
All right, Mr. Disbrow, anything else that you'd like me to know?
No, just what's next? What do we do?
Well, I am going to find that in my last order, I did find that there was a violation of the code sections, and then you had 30 days to determine whether or not there was a legally non-conforming use or if there was another way to bring the property into compliance. At this point, since there isn't a legally non-conforming use, and Mr. Curtis has just let me know what compliance looks like, it looks like all that really means is that the kitchen needs to be removed and there can be nobody living down on the first floor.
Okay.
Do you know, are there tenants in the
Oh, yeah.
first? Okay. So,
Long-term leases are in place, all sorts of stuff, yeah.
okay. So, yeah, that is a little bit difficult. Do you know if the leases include any type of termination provision with a written notice period?
I'd have to look again. I think it was a 90-day, but yeah.
A 90-day? Okay. I mean, I also do think that's fair to remove a kitchen. It's going to need a demo permit most likely. So I'm going to do this. I'm going to continue with the violation, but I am going to set a status check for 90 days. And that will allow for you guys to work with the city to do whatever needs to be done with the tenants, to work with the city to figure something else, and then we'll meet back here. I do want to have you make good faith efforts to come into compliance, whatever that ends up meaning, because maybe that there's an alternative route. I don't think that there is. And then we'll check back in 90 days. So that will set us at let's push it to the December 14th hearing. And that way that gives you time to figure out what next steps are.
Okay.
So I will issue an order to that effect. So there is a violation on the property. I found that last time, but no fines are going to be assessed at this time, and we'll come back on December 14th and figure out where you are as far as compliance is
All
concerned.
right. Thank you.
Thank you, Mr. Disbrow.
Madam Special Magistrate, Pete Dewar, Code Enforcement, could we also include in that order an application for a permit?
I'll put an application for a
Demolition,
permit
yes, please.
if necessary. If there is another avenue and that's something creative or somebody finds something, I don't want to.
Or other avenue?
Right. my concern is they haven't operated, the current owners purchased this property subject to this 20 years ago.
Yes, ma'am.
So this is not new.
Correct.
And there was a variance in 1983. Understanding permitting records are not always kept. They're not always kept in order. There are plenty of reasons that this might have actually been properly permitted, and there's just, I want to give as much time to rectify the situation,
Sure.
understanding they still need to be compliant with the code. So I will put to apply for a demolition permit if necessary,
Thank you.
of course. Okay, moving on to agenda item 3B, case number 20260168, City of St. Pete Beach versus Roma Invest Group, Florida LLC.
Good morning, Special Magistrate Lucy Knight. They applied for a permit, but they went past their date because it hasn't been approved yet. So your date was as of Monday, July 27th. We're asking for $250 a day until they come in compliant, and $350 for admin fees and any other fees. But I also have Miss Joanne here, so she could speak on the permit.
Okay, so my order said they had 14 days to get an after-the-fact permit by Monday, July 27th. You're saying they have not obtained the after-the-fact permit?
No.
They've applied for it, but they have not obtained it?
Yes.
Okay. And you said it was $350 for administrative fees?
Yes.
330.
$330, thank you. And $250 per day, okay. And Ms. Bolin?
Good morning.
Good morning.
Just real quick, I just want to give an update on the permit. It is in review now. The fees were paid on August 6th, and it is in review. Once the review is approved, all we need are the subs to sign on, plumbing and electrical to sign on to the permit, and we will be able to issue the permit.
Okay. And you said they didn't pay the permit fees until August 6th?
Yes,
When was the application submitted?
July 20th.
Okay. Thank you, Ms.
Thank
Bolin.
you.
Appreciate it. Is there anyone here on behalf of the property owner? Anyone here on behalf of Roma Invest Group, Florida LLC? Ms. Knight, have you had any conversations or any contact with the property owner?
No, ma'am.
Okay. I am going to find that the property is still in violation of the stated code section as well as my final administrative order. I am going to assess a $250 a day fee from Tuesday, July 28th until the property comes into compliance, as well as the $330 in reasonable administrative fees of the city. Moving right along to 3C, case number 20260134, City of St. Pete Beach versus Plaza Beach Motel LLC.
Good morning, Special Magistrate.
Excuse
Madam Special Magistrate.
excuse me. The last witness, I don't believe, was sworn in. So,
Ms.
Ms.
Bolin.
Bolin?
yes.
Okay.
So if she can,
She's not even here. I actually did not necessarily consider her testimony.
Oh,
right,
I appreciate that.
okay.
I think we should bring her back in to swear her in and then just verify the testimony she gave was the truth, but I took my testimony from Ms. Knight for the most part.
thank you. Lucy.
You can just raise your right hand to be sworn. Do you swear or affirm the testimony that you just gave was the truth, the whole truth, and nothing but the truth? Yes. Thank you, Ms. Bolin. Thank you. All right. Thank you for notifying me of that. I appreciate that. Okay. Now moving on to item 3C, case number 20260134, City of St. Pete Beach versus Plaza Beach Motel LLC.
Good morning, Special Magistrate Lucy Knight. Let me see, wait a minute. This is a status hearing for the property that was purchased from Cezanne in 2022. Duke had it in 2008, and we was supposed to go back and get some information, and we have them.
Okay,
So,
what you said is the property used to be owned by Duke Energy and then was purchased by Mr. Cezanne in 2022. Is that
yes,
correct?
ma'am.
Could we present that evidence on the overhead, please?
So the city would like to enter into evidence the Google map pictures. This is 2008. I'm sorry if you can't see them that well.
Okay.
Could you zoom in, please, Jamie? Thank you.
2008. And here are the poles, right here, on the property in 2008. This is 2011. And have all the poles and the rock pile that's in the back. 2014, still have the poles. 2015, 2016, 2019, it still has the poles on the lot, electrical poles on the light. And all this existed with Mr. Cezanne all the way back to 2008. Additionally, we didn't break ground until 2023, and I have proof. This is the city commission meeting, City of St. Pete Beach, and right here where it says we want expected construction start date till spring of 2023.
Could you go back to that first page, please? What are we looking at? What date was that agreement? Or that agenda report, rather? November 10, 2021.
2021.
Okay, in my order, and I understand that I guess my question is, Duke Energy had the poles and the rocks on there beforehand. There was no code enforcement action against Duke Energy. Mr. Cezanne brought the property in 2022. He was concerned that the city was using that as a staging ground for a specific thing, but maybe not. My order says that I wanted to make sure that things that were on the property were not
It's not the
city
city's.
property,
No, ma'am.
but they were Duke's property beforehand.
Yes.
And the city at no point used Duke's property as a staging area for anything at all either.
No, ma'am.
Could we look at the pictures of May 21, please? And the construction that started.
This is November 2021.
Jamie, please zoom in.
Okay, is this the city's construction?
There was no,
Using it
the
as a
city,
staging area is
you-
my question.
we do not know if this was a city project. We're saying that the city project would have been started in the date that was in 2023. There is a staging area. We don't know if this was being cleared prior to the purchase by Mr. Cezanne, or if Mr. Cezanne worked with Duke to construct or put something else on the property. We don't know that.
Okay, but you can testify here today that the city at no point had an agreement, either formal or informal, with Duke or Mr. Cezanne to use that area as a staging area for any project, not even just the one that was mentioned before, because I think the testimony before was he thought it was for that project but wasn't sure. I just want to make sure that the city is not asking private citizens to remove city property from private property.
As the testimony has proven and the photographs that we entered into evidence proved, those two electrical poles have been existing on that property since 2008.
Sure, and I don't have a problem with
And
that.
so-
My question is, has the city always had, or have they had some sort of agreement with the property owner, whether it be Mr. Cezanne or Duke, to use that property as a staging area? If the answer is no, then...
The answer is no.
Okay. All right, thank you.
Thank you.
Appreciate that. Anything else, Ms. Knight?
And this is what it looked like in January. And this is what it looks like now as of August 7th, which was Friday.
Are the poles still on the property?
And the poles are right here and the pile right here with the grass growing over it. Plus he added 2 extra trailers on the property.
Okay. Thank you, Ms. Knight. Is Mr. Cezanne here, or anyone here on behalf of Mr. Cezanne? If you could please come, state your name for the record, and identify if you've been sworn or not.
Yes, my name is Alyssa Gagnon. I'm an attorney at Weber, Crab, and Ween, and I have been sworn in. I'm actually here.
Miss, can you spell your last name again?
Yes, Gagnon.
All right, Ms. Gagnon. Okay, and what evidence do you have in support of
Yes, I actually have a lot prepared on agenda item number 7, but my last conversation with my client about this matter was that he was still concerned it was city property, and he would be taking something that taxpayer money was used, you know, to purchase off property.
Sure.
But
And he had an obligation to also put forth evidence to supply that there was an agreement either with the previous property owner or with himself to use that property as a staging area. Does he have any evidence to support that that was the case?
I do not have in front of me evidence today to support it. I was recently retained in the matter, but if I could do further research, I could affirmatively answer that.
Mr. Cezanne was here last time. He is fully aware of what he was supposed to do prior to this hearing, so I appreciate that, but there won't be a continuance granted on this one.
Correct. Thank you, Special Magistrate.
Of course. Anything else that you would like me to know on this matter?
That's all.
Okay, thank you very much, Ms. Gagnon. I am going to find that the property owner is in violation of the stated code section. I did not give an opportunity to cure. I just gave an opportunity to find out if it was city property. There's been sufficient testimony here today, credible testimony, that the city did not have any type of an agreement, formal or informal, with either Duke or Mr. Cezanne, the current property owner, and that Mr. Cezanne has it's a rock pile and some electrical poles?
Yes, ma'am.
Okay, he has 14 days from the date of my order in order to remove those 2 items from the property, and then we will meet back here. I should have already had this date in my head. On September 14th in order to determine any compliance and to assess any fines if necessary.
Thank you, Special Magistrate.
And Ms. Gagnon, if you can make sure I have your email address, then I can email the order directly to you.
Right there. Thank you.
Okay, moving on to 3D. We have case number 2026-0245, City of St. Pete Beach versus LCP South Postcard Inn LLC. Is the city going to present anything? Oh, it's going to be Mr. Dewar.
Good morning, Madam Special Magistrate Pete Dewar, Code Enforcement. The case against Postcard Inn, or no, the Loose, we did readings last week, and the property was compliant. We went by there this morning to do an early morning reading, and unfortunately, when staff got there, a member of the Silver Sands Property Ownership Management, they were unable to make it. They had a medical issue, so we were not able to do that early morning reading. But at this time, we have not had subsequent complaints to the Postcard Inn or the Loose working towards compliance, and they have substantially lowered the noise that we gathered last week when we were there. So for all intents and purposes, we can make the claim that they're currently compliant since we have not gotten any additional complaints. And the attempt this morning was to determine full compliance with not just during the day reading, but an overnight, early morning reading, and we weren't able to do that. So I don't know if we should necessarily continue the case. I'm going to leave that in your hands to make that decision, or if we can claim compliance based on the fact that we did the readings last week, and I have evidence that we can enter.
Look, I'm not the one that determines if the property is in compliance. I can verify what the city says to determine if it's reasonable compliance, but it is up to the city to determine if it's compliant with the code. I do believe there's a representative from the property owner here, so maybe prior to my making a determination on that, we can hear from him, and then, because I believe my last order was just to give them a good faith effort. I kind of like to hear what they've done in the interim, to see if maybe the readings would come back as compliant.
Good morning. For the record, Kevin Reale, 401 East Jackson Street, Suite 2100 in Tampa, for the property owner. So, as we discussed last meeting, there are two ways to try and comply. One is, every piece of equipment, as I'm learning slowly, every piece of equipment has some sort of software control in it. And the software can control the frequencies of the fan motors and the blower motors. Frequency is speed, but it's more than that. There can be resonant frequencies and all other ways to reduce noise. And there are 2 units, and one of the units, so they adjusted blower settings and fan settings on using a computer. And on one of the units, adjusting the fan setting created a significant reduction. And on the other unit, the blower setting, for whatever reason, that was more of the culprit. So I have a report. It's black and white. I'm happy to submit this, but I can also email it to you if you want the color report. But they saw a 10 to 13 decibel reduction by changing those speeds. And then, of course, the unit doesn't have to run quite as hard at night. So as it gets cooler during the night, it's better during the night as well. We were expecting the measurement this morning as well, and we're hoping that it will comply. And we can hear a significant reduction, but the only measurements we have were during the day. We don't have the measurement that they were trying to take this morning. So we believe that we have more than a 10 decibel reduction, which would make us comply. But I have evidence that could show you they comply during the day, but I don't have evidence to show you they comply during night.
So I guess my question would be, if you have evidence that demonstrates during the day it's a 10 to 13 decibel reduction, do you have any reason why it wouldn't be the same at night if you're running over a course of time?
No, and actually we would think that it would be the same because the last reading during the day, when I looked over it, the ambient didn't create a reduction. So the biggest problem taking measurement at night is you may not have ambient helping you, right? So during the day, if it's noisy, that ambient, the delta between the ambient and the actual noise might be less. So even though the machine is just as loud during the day or the night, it might not have the ambient reduction. So we expect it to be the same. We were hopeful that that would be the same, so we don't have any reason to think they wouldn't comply, and I can submit the evidence showing that we have the 10 to 13 decibel reduction. And this is all with software and with the existing equipment. One of the things that was discussed last time was doing a physical barrier, and the issue with that is the noise is being read above, right? The neighboring property is taller. So it would be the physical damper would be, it wouldn't be as simple as putting up like a screen, right? And so the estimate for that is a 6-month manufacture, because it's custom manufacture, custom design, and then install. So if there is no compliance, then it would be, after the reductions that were just done, then it would be a significant time before something like that could be done.
6 to 9 month window.
It would be. And that's why so much effort has been put to trying to do it with the machine, because as I stated last time, this was never supposed to be this loud. The machine is not supposed to run, and one of the culprits was one of the fans was running on overspeed, so it was running wild, so to speak, and that's some of the noisiest things that are up there because the machine itself shouldn't be that noisy. So that was a big help, and then playing with the frequencies to find the right combination help.
Okay. If you would, you can just leave that with the clerk for evidence, and it can be considered part of the record.
So I have it's a short field report basically confirming the measurements they made, and then there's an email chain describing what happened, which is helpful background.
Yeah, if you want to submit that, that'll be good for the record, and then I can get a copy if needed from the clerk.
No, that's fine. You can.
Anything else, Mr. Reale, that you would like me to know?
No, thank you.
Okay, Mr. Dewar, I do think it might be beneficial, just because I know there were quite a few property owners that were impacted by this, to perhaps continue this till the next hearing.
Okay.
Just
We
to
do
get
have,
We have-
there is a fact witness here.
We
the
have the
neighbor.
manager of the property where we were taking the readings this morning. He's
Okay.
here.
If, yeah,
He would like
absolutely.
to say something.
Good morning.
Morning. If you could state your name for the record.
My name is Mir, M-I-R, Kavaric, K-A-V-A-R-I-C, last name. I'm the general manager for Silver Sands Beach and Racquet Club. I did review those readings. Our apologies that our guard captain today actually got sick. That's why you could not get the readings as scheduled. When I spoke to the general manager of Lelou's postcard in, I'm so used to say
Yeah.
PCI. And I actually was in New York when he called me, and he did tell me that the air conditioning, chillers, whatever you want to call that equipment, they did some software adjustments. According to him, it was that because the temperatures were set so lower, that's why the system was kind of running more and louder. So that brings us as Silver Sands to something else. They just simply made few adjustments and they increased the temperature. We do not know the occupancy of that lobby or the restaurant when any other amenities inside that would require in the future for the system to be adjusted. The logical outcome would be that why would you get this big system if you did not need on the full support? So we believe that the readings should be done when the system is using the maximum capacity, because this is going to be in the hands of the loose. If they need more air in the future, the system is going to be louder, which means we're going to circle back again and we're going to start this procedure which has been going on since March. Even with this new adjustments, so-called, there is still actually a noise factor in all those units. It's besides the decimal, it's the nuisance of those property owners. I can hear right now at the clubhouse where my office is located almost 250 feet away, and I can hear that equipment actually running. Now imagine this at night. Those balconies, I do disagree with the fact that placing acoustical barriers is not going to work. I think engineers will tell you otherwise. There's not even a single high-rise building that I know of, and we all have traveled, that they do not have an acoustical barriers. There are calculations can be made, even in regards if the noise goes up, which I do agree. Lelou's is a second floor, our building says 5 floors, and doesn't include the garage. But we do not basically believe that whatever adjustment have been made right now has remedied the problem. Yes, maybe the readings are showing otherwise, but this is just a temporary solution just to be in compliance. This is not a permanent solution. We'll be back on the same place in a very, very near future. Thank you.
Thank you very much. Okay, anything else from the city?
Actually,
I was going to say, Mr. Reale, did you want to speak to Mr. Kavaric?
yeah, so it sounds interesting. That's why I was starting my testimony saying, yes, they go in and change things with software, but the unit is either on or off, okay? And so when it's running, and the way the computer was running it, the computer was not set up properly, so the control unit was telling fans to run at overspeed, and then other portions of it were running in resonant frequencies of one another. So this is not some made-up thing. A professional came with a decimal meter that you can see in the report and measured the change. It went from 85 plus decibels at 10 feet away. It was a significant reduction. So I would just point out that the engineer can show you, you can see the math, there is a reduction, and the unit's running or not, right? And so it's like your compressor at home, right? When your air is running, it's just how often it's running is what would change. And it's also the hottest month of the year, and the measurements were taken, and the measurements also note the temperature and humidity and those things, and they were noting that the system was still operating properly even though it was quite hot and the conditions were not favorable for conditioning the space.
Okay.
So all that's in there.
Thank you, Mr. Reale. And Mr. Dewar, can you tell me what time of day were the daytime readings taken, where you found that the unit was in compliance?
After 7 a.m., which is, makes a difference because the decibel level goes up a little higher.
Right, so do you have the time, on the last reports that I received from Ms. Rectichel, we had the exact time frame.
8 a.m. in the morning.
So they were taken at 8 a.m.? Okay. Okay. All right, so I appreciate everyone's testimony. Mr. Clark, to your point, I'm only here to determine compliance with the code. So whether or not you are back here in the future is going to be up to the city and whether or not this is the fix that lasts. Noise is allowed to happen. It's just as the city regulates it, how loud it's allowed to be. That being said, I do want to make sure that we have compliance with the daytime level. It's the nighttime level that we don't know if we have
Correct. Yes,
compliance
please.
with. So I would like to make sure that let's come back in September. That way you have 30 days, the city has 30 days to get out there and make sure that the overnight is impacted by that 18 decibels. That'd be nice, right?
Yes.
10 to 13 decibels. I suspect it will be, and maybe Mr. Reale won't need to be here next month, but let's just get that confirmation so that
Very good.
we can close the loop on that, and I can make sure that the property is in fact in compliance both with daytime and overnight decibel levels.
Thank you.
So I will get an order to you all, and if need be, we'll be back here in September. If not, then it's nice to handle that for you all. Okay, moving on to agenda item 3E, case number 20250220, City of St. Pete Beach versus Mr. Sarkis.
Good morning, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. This is a status hearing for 1104 Pasagrove Way. The last hearing, I believe we were waiting for Mr. Sarkis to go to closing. I checked property appraiser this morning. It shows Mr. Sarkis still owns the property, so I don't know if the deal fell through. I believe Mr. Sarkis is here to maybe speak on where he's at with the property.
Absolutely. Hey, Mr. Sarkis, how are you? Go ahead.
So yes, I had the property on the contract, but buyers, with unknown reasons, they just changed their mind, and they are not buying anymore. So after that, I hired company, High Tide Home Pros. I signed contract with them for a full renovation of the house. I have notice of commencement, contract, I pay deposits, architect and engineers working on the drawings. They already applied because they probably asked for a few permits, so they already applied for replacing the roof because they probably can do that until architect working on the drawings. So I have all that paperwork and
Okay.
the contract, paid deposits, and
Okay.
the rest.
So just making sure, so now that you decided through all this, you're going to keep the property.
I don't want to keep it,
You don't want
but
to,
you
but you kind of
understand
have to at this point.
It's not my fault. Those people, they were just such a liars, and
Yeah, okay.
and that's what happened.
And so you've already got a contract with your general contractor. They pulled a roof permit, so you're planning on renovating, not demolishing and rebuilding, correct?
Yes, correct.
Okay. Do you have a time frame on when the remainder of the permits are going to be pulled?
So for the roof, they already applied for the permit, and the rest because there is a lot of work for architect and engineers because it's large project, huge house. It is more than $1.2 million project, and they're rebuilding practically everything because replacing siding, balconies, all doors, windows, roof, everything inside, 100%, moving some walls. So there is a lot of work to make new drawings.
Okay.
And I hope, because we have contract for 8 months, it's supposed to be done. I don't think they're gonna make it till that time, but
Okay.
But they're working on it already. So.
Okay. All right. Thank you, Mr. Sarkis. Anything
Welcome.
from Mr. Rivera? I know.
We were going to request fines to begin today. I mean, if he's got a roof permit application in,
Yeah, I have it.
I'm not sure where we even go with this. The case has been open since '23, I think it is. '24, I'm sorry.
After hurricanes.
25. 25.
Yeah, and look, every time Mr. Sarkis has had to be here, he's been here. And I see your face, Mr. Rivera. He's been working hard to try and remedy it. It's just every time there's an opportunity to do something, it seems to get pushed back. So
I'm trying.
yeah, it is a difficult situation. The point of code enforcement is to garner compliance, not to be punitive. I do believe you are trying to comply. Anything from the city attorney that you have any points on behalf of the city for this?
Only that a time limit be given to him to get something done.
Okay.
So.
Let's do this. I'm not going to put the full 8 months out there. I agree with you. I don't think they're going to be able to get it done in 8 months, but I do want to kind of keep a pulse on this. So let's do 90 days from the date of my order. We'll come back for a status conference, and then you can give us an update on where they are. Maybe additional permits are being pulled. I understand from the city's perspective, it's an exterior. That's at least what was in this violation. It was the exterior, the siding, the roof, those types of things. So if any of those can get done before interior renovations, I know it's easier to do it under one major permit, but
It's impossible because everything is connected. Let's say windows and doors, they are coming different sizes, and they can't do. Of course, it is probably number one, windows and doors, but it is special order. There is. It's not regular sizes. It's very different. There is like three practically window walls. So it takes 2-3 months just to create them and fabricate them. Plus, engineers, they have to find out that everything fits, and so architect working on that. After he will finish, so he has to approve with the city those drawings. They can't order before that, so only after that they can order those all those items. And
Okay, yeah, let's set it for 90 days, and then that way we can come back and we can see if they've completed the drawings, how far they are on them, if they've submitted for a permit, and then we can kind of task it from there. At some point, there is going to have to be a drop-dead date where we say you don't have to maybe be completed, but you got to be far enough along where this doesn't become a problem. So I will get you a copy of the order, have your information, and we will see you back. Let's see. I said 90 days. That's actually going to put us at 89 days. So let's do December 14th. Okay. Okay. We'll come back on December 14th and see where you are.
yes, thank you.
Good luck to you, Mr. Sarkis.
Thanks.
Okay, moving on to agenda item 3F, case number 20230606, City of St. Pete Beach versus Mark Broderick and Lynn Broderick.
Good morning, Madam Magistrate. Steve Rivera again, City of St. Pete Beach Code Enforcement. This is a status hearing for the unpermitted auxiliary structure that was built behind 3535 Bella Vista Drive East. Mr. Broderick, they were given their variance. They have permits in review currently. I think they have to make some changes to the building structure before the permit can be issued. So we're just asking to continue this to the next hearing.
Okay, anyone here on behalf of the Brodericks? Okay, if you can come state your name. Do you want to even say anything?
No.
Okay. All right, then never mind. Then we will go ahead. We will go ahead and continue the hearing till the September 14th hearing at 10 a.m. And work through that process.
Thank you.
All right, moving on to agenda item 4A, case number 20260274, City of St. Pete Beach versus McNapp Properties.
Good morning, Special Magistrate. Lucy Knight, case number 20260274, McNapp Properties, address 6405 Gulf Boulevard. Violation description: the property is in violation of section 26.A B 1, C, D, and 2. Inspection and maintenance of signs of the Land and Development Code of the City of St. Pete Beach. Case summary, initial inspection was 5/14/2026. Notice of violation dated and mailed 6/12/2026. Notices of a hearing dated and posted on the property 7/14/2026. This picture is a true and accurate description of what was posted on the day of it. This is the affidavit of posting. This is the damaged sign. This is the one that's in the back. The owner must replace or repair the sign. Property is not compliant. Recommended fine is $250 per day from the date of your order, plus $330 administrative costs and the actual costs incurred in recording or releasing the lien of this matter. I have been in contact with the property manager, and I've been trying to work with them, but they still haven't came into compliance.
Okay. Thank you very much, Ms. Knight. Anyone here on behalf of McNatt Properties? Anyone here on behalf of McNatt Properties? Okay, seeing no one, do they need to get a permit in order to repair that sign?
No, ma'am. They were supposed to install some blanks in it, but they haven't, and it's been since May.
Okay, I will allow 14 days from the date of my order in order to come into compliance. And then we will be back here on September 14th to see about if they're in compliance and if any fines or fees need to be assessed.
Thank you.
Moving on to 4B was continued, so moving on to 4C. Case number 2026-0041, City of St. Pete Beach versus Farida Hanamore and Javid Hanamore.
Thank you, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. Case number 2026-0041. Respondent is Farida Javid and Earl Hanmore. Violation address is 2380 East Vina Del Mar Boulevard. Violation description: property is in violation of Section 9866A, B, 20, 24, 27, and E, residential and commercial property maintenance. 4633B, enumeration. 22.1, purpose and intent. 22.3D, general requirements. And 23.11A, 1 and 2, parking construction and design of the Code of Ordinance and the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection was 1/26/2026. Notice of violation dated and mailed certified 4/6/2026. Notice of hearing dated and posted to the property 7/8/2026. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 2380 East Vina Del Mar Boulevard. This is some of the outdoor storage. There's a wheelbarrow and a leaf blower. This was miscellaneous items stored over near the garage area. So another date, there was some wheelbarrows stored outside and a leaf blower. It's a picture of some of the dead vegetation that was on the trees, some dead fronds. Another picture of the dead vegetation. There's the overgrown weeds on the property. And it's showing the weeds coming through where the pea pebble was in the front yard. This was the parking on the unimproved surface. It was parked in the pea pebble, not on the driveway. Another picture of the vehicle parked in the pea pebble. Corrective action: the property must maintain the ground covering as designed, park on the improved surface, and store lawn equipment and other machinery out of public view. The property is compliant. This should have just had the administrative fee for the recommended fine, plus any cost and actual costs incurred recording or releasing the fine in this matter, the lien in this matter. And that concludes my presentation.
Okay, thank you, Mr. Rivera. Anyone here on behalf of the property owners? If you could please come up and state your name. And I believe you were sworn in earlier, correct?
My name is Farida Hanmore, and I'm sorry that it got as far as it did, but Mr. Rivera had my wrong phone number by 1 digit, so but once we got the right numbers, we've been communicating, and I've taken care of everything, and I'm sorry it's taken me kind of long, but I'm on disability, and I'm on a very fixed income, and if there's any way that you could waive some of the fees, I would appreciate it. And I want to thank you for being he was been so nice and helpful, and like I said, I'm sorry he had my wrong number by 1 digit, so I think he thought I wasn't answering his calls, but I was, once I got the right numbers. And again, I'm sorry.
Not a problem. Did you receive any of the notices? Because it looks like this had been going on since January.
I did receive the notice in the mail, yes, ma'am.
Okay. Thank you so much, Ms. Hanmore. I appreciate it. There are no fines or fees. I'm going to find that the property was in violation but is now compliant before the hearing date. I typically don't waive the city's administrative fees because they have to pay for my time and the notices and everything to get you to come here. If you had complied before when the notice was originally sent, this wouldn't be an issue. So I appreciate you asking for the request for the reduction, but I am going to assess the $330 in administrative fines of the city. Mr. Rivera, you asked for recording and releasing of the lien, but there's no fine assessed with it. Is that just something that the city is requesting from now on, or has?
As for language, we've been questioned. Well, they said it was only going to cost this much, and then there's the releasing or the lien, recording the lien. There's a fee with that.
Sure.
To release it. So that's what we're looking. Make sure it's just in the language.
Okay, but there's no fine that's being assessed, so there wouldn't be a lien that would be assessed with this.
Yeah, our administrative side takes, like I said, we're just trying to keep the language all uniformed with.
Okay, understood. Okay, not a problem. Okay, so I am going to assess the property is in compliance. I will get an order that says that there's the $330 in reasonable administrative costs of the city, as well as the language with regard to recording or releasing a lien if appropriate. Thank you so much.
Thank you.
All right, and moving on to agenda item 4D, case number 20260318, City of St. Pete Beach versus Gregory Williams and Marcy Williams.
Sorry about that, Madam Magistrate.
No worries, Mr. Rivera.
Bring this up here. Case number 20260318. The respondent is Gregory and Marcy Williams. Violation address is 3922 Poinsettia Drive. Violation description, the property is in violation of section 98-123.1, permits required, and 4633(1), 2, and 3, enumeration of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was 5/28/2026. Amended notice of violation dated and mailed certified 6/18/2026. Notice of hearing dated and posted to the property 7/23/2026. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 3922 Poinsettia Drive. This is a picture of the unpermitted fencing that was being installed. Another picture of the fencing supplies and the concrete. The stop work order that was issued to the property. Corrective action. The property must cut and maintain the grass and weeds regularly and obtain a permit for the fence installation prior to completion. The property is not compliant. Recommended fine is $250 per day from the date of your order, plus $330 administrative costs and any actual costs incurred in recording and/or releasing a lien in this matter. And that concludes my presentation.
Okay, anyone here on behalf of the Williams? You could please come up, state your name and affiliation for the record.
Good morning, Your Honor.
Good morning.
Gregory M. Williams.
Okay, Mr. Williams, what do you have for me today?
Well, let's see. So we have, one of the violations was a car that was parked unregistered. Here is a, may I approach?
You may. And is that part of the violation that's
It
here
was
before?
the original notice, one of the original notices that went out. That's not part of what I was presenting.
Okay, so then that's okay. I will take your valid testimony that the vehicle is registered. That's not before me here today. The only things before me are the overgrown landscaping and the unpermitted fence.
All right. That's part of it. So we were able to get a permit for that fence line. So that was,
Do you know when that permit, because there's nothing in our system showing a permit for any fencing going in.
so I was told by this homeowner,
Okay.
because he had a survey.
Saying it was his fence. So what about the sections in the front here?
What are we looking at, please? Could we put us on the overhead?
So when I applied for when I got the amended notice of violation, I wasn't living there. We were still in our rental property trying to move back in.
Mm-hmm.
So when we got the stop work order, I went down the next day to apply for a permit for the fence. I had a survey with the city. The city lost the survey, and they told me because I did not have a survey, they would not permit my fence. So my neighbor had a survey, so we were able to permit that side of the fence and got that fence installed and permitted. My understanding was the city, I don't know, for somehow they lost the survey, so I had to first go to the original title company and see if they would give me a copy of my survey. They were not able to find it, so I went to my mortgage company. When I refinanced, they had a survey. They were not able to find a survey and provide it to me. So I went back to the original people that did the survey, and they came out on Tuesday of last week.
Mm-hmm.
And then as soon as I paid them, they emailed me a survey, which I have with me today. And before I came in here this morning, I went to the city and applied for a permit. So I have a permit pending for the fence. It is not in review yet because the survey, I did not put down the linear dimensions of the fence that is now being hopefully permitted.
Okay.
I don't know, there was an issue with, wait, I think I have that here, with property that was, or things that were on the front porch. And that is a photo from yesterday showing that, and that is the screen there, which was part of the original report. And as you can see, everything that was on there has been removed except for an umbrella.
What's allowed to be there? Okay.
And I think that's it.
Okay, and I think, Mr. Rivera, did you say there was overgrown vegetation?
Yeah, so where the vehicle was parked at, that wasn't the original notice. There's overgrown vegetation, some broken pottery plants, which I apologize, I didn't see it. I think I went through the slide too fast where that pile of fencing material was at. But there is some overgrown vegetation that needs to be addressed sporadically here and there. We have 12 inches tall spots of weeds. The fence is the major concern, obviously. to make sure it gets permitted before installation.
Okay, and I'm assuming, Mr. Williams, once the fence is up, then the yard will be contended with, if necessary.
Yard got mowed yesterday by me.
Okay. So the yard has been contended with, okay.
Yes, and it's just, as I said, we did not move back in
Right,
until,
you're still in a rental at this point, yeah.
and so we've been back in since July, or I've been back in since July 8th, I think it is. So that's, all that stuff that you've seen has been done
It's
since then.
starting to get done. Okay, okay. And Mr. Curtis, I know that you just walked all the way back there, but would you mind letting me know how long a fence permit might take to be issued for Mr. Williams or thereabouts? Understanding I'm not holding you to it, I just would like to know an estimate. Mr. Williams, if I could have Mr. Curtis come up and just, thank you very much, sir.
So as far as it requires 2 reviews, building and planning and zoning. So it's a quick, short review. Once we get all the documentation, providing it's accurate and provides all the information we need, I mean, it could, technically, we have 30 business days to review it, but we're getting them processed a lot quicker, within 2 weeks typically.
Okay. Okay, thank you, Mr. Curtis. Mr. Williams, is there anything else that you would like me to know before I issue my ruling?
No, no,
Okay,
ma'am.
and Mr. Rivera, anything else further from the city?
No, ma'am.
Okay, then I am going to find that the property is in violation of the stated code section, but I am going to allow for 30 days from the date of my order to come into compliance. And what that will look like is that you receive a permit for the fence. Doesn't have to be closed out, but you get the fence permit, and you've already shown that the grass is already mowed and that the remainder has been complied with. So with that being said, that date puts us at, then we'll be back here at the September 14th meeting if we need to.
And that meeting will be postponed if the permit has been,
We will be back here either way. The only reason you might not be here at the September 14th meeting would be if the property is in compliance. Otherwise, you will need to come before me and let me know why it's been postponed, et cetera, et cetera. If it's an issue, if I couldn't get a hold of my surveyor, couldn't put the linear dimensions on, they were running whatever behind, or if it's just, I just didn't do it, I need to know either way, so that I can either assess the fines, find the property in compliance, or continue it to another date certain.
I understand. And is September 14th a Monday?
It will be a Monday.
Okay. The only thing I would bring to your attention is that my court appearances are scheduled far in advance. So if you could, I can go to the judge and get them reset if you could give me an extra 2 weeks beyond that, and then I can.
I don't set the hearing schedule for the City of St. Pete Beach. They are second Monday of every month, and they have been since as long as I've been doing this. I can set a 30-day deadline and put us at the October hearing, but you still only have 30 days to come into compliance. It would just be whether or not we touch base in October.
That would be great.
Okay, is any objection from the city on that?
No, ma'am. Just urgency. There is a swimming pool on the property, which I forgot to mention. With the property not being secured, that's a concern as well.
Okay, and I can understand that. I've got testimony from the property owner saying he submitted the permit.
30 days, yeah.
Right, and then I've got the 2 weeks really turnaround time, but because there's a statutory requirement for 30 days for allowance, I'm giving that 30 days.
Understood.
So it will be 30 days to come into compliance with my order. That will be to secure a permit, because the violation is for unpermitted work. And then we will come back, I'll set a status conference for the October
12th.
12th date. And if I see you then, I'm sorry. If I don't see you then, great. That probably means the property's come into compliance. I would just encourage you to stay in communication with the code enforcement department, because sometimes everybody's busy at the city and sometimes building and planning don't talk to code, and just to let them know that you're still working on it.
Thank you.
Thank you, Mr. Williams. I appreciate your time today. All right. And we are moving now to agenda item 4E, case number 2026-0399, City of St. Pete Beach versus BRE Mariner Dolphin Village LLC.
Thank you, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. Case number 2026-0399. Respondent is BRE Mariner Dolphin Village LLC. Violation address is 4665 Gulf Boulevard. Violation description: property is in violation of Section 38.5, prohibited uses and structures, and 4.1A, B, and C, review of conditional use permit application of the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection was 7/28/2026. I notice of violation dated and mailed certified 7/28/2026. Notice of hearing dated and posted to the property 7/28/2026. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 4665 Gulf Boulevard. This is the parking advertisement signs that were located on the property. Another parking sign. This is a screenshot. If you scan the QR code showing what it would cost for 7 hours. I know it's a little stretched there, but it shows $52.50 for 7 hours of parking. Outlined in the red was the area that was designated for the parking sales. It's a vehicle parked within the sale area. Corrective action: the property must cease the sale of parking without the proper permits. The property is compliant. Recommended fine is $1,000 per day, starting 7/28/2026 through 8/4/2026, 8 days, plus the $330 administrative costs and the actual costs incurred in recording and/or releasing a lien in this matter. The total for that would be $8,000 for the 8 days. And that concludes my presentation.
Okay, I have questions.
Yes, ma'am.
So the violation is for prohibited use of the property without the proper permits, is that correct?
So they were selling parking. It's not a use that's,
You're not allowed to have paid parking in that particular zoning?
yes, ma'am.
Okay, and they were having paid parking in that particular zoning district? You're allowed to have parking, it just has to be free parking or affiliated with a particular business?
So they could apply for conditional use. Whether or not they would get it, I don't know.
Okay.
That would be planning and zoning. But there's no application as of right now for, to sell parking space.
Okay.
So we're kind of treating it like a short-term rental. Can't unsell the spaces. And that's why I issued it as,
All reversible.
yes, ma'am.
Very creative.
Yes, we are.
I'm going to need a little bit more on that. So you said that they're now compliant?
Yes.
Which means that they're no longer using it in the manner that they were using it before, correct?
No, so I've spoken to, and I believe one of the representatives from the company from Bricks Morris here. They did remove the signs. They have stopped parking since. And I guess moving forward, they're going to try to figure out what they want to do with the parking.
Okay, and if you're making it akin to a short-term rental, when you issue violations in the city for a short-term rental, there's the advertising, which can be cured, and then there's the actual parking. So what you've shown me was there was one vehicle parked there. Can you confirm that that vehicle paid for parking in that lot?
I cannot. I did show the advertisement for the parking and the QR code showing what it would cost for 7 hours of parking. That vehicle was parked within that cordoned off area.
Sure.
During the times that you would have paid for parking.
Sure.
So I'm going to assume that vehicle was there, paid for parking, and went over to the beach.
Okay, and the reason I ask that is because when you present to me short-term rentals, you present to me reviews that determine that somebody actually paid and rented and stayed there.
Yes, ma'am.
And so you can't put the toothpaste back in the tube. I don't have that same type of evidence here. And you also you ask for $1,000 in fines for irreversible because you can associate them with the reviews. You've asked for $8,000 worth of fines, but you've shown me one vehicle that was parked there, and you don't know whether or not they've paid for parking.
I don't. So, originally, just to give you some background on it, I wrote the property up. I did try to reach out to a previous employee that was there. I was unaware that that person wasn't there. The day I went to go post it, the signs were gone. So I closed the case. A day later, I come out, and they were back there, and there was a couple of vehicles at the time, which I probably should have grabbed photographs of. I did not, but on the day that those photos were taken, there was a vehicle there. There was a forklift that was also parked over there. I don't think that's associated with it. but I'm assuming that they're very strict with the parking over there. That place is known for having vehicles towed out that's not supposed to be there. So I'm going to assume that that vehicle paid for parking and was parked there. I know it's not a review.
It's a lot of conjecture and assumptions, but anything from the city over here?
Well, Madam Special Magistrate, yes, you are correct that there are certain things that we provide you when we do the INI. But this case is for 38.5, which is prohibited uses. You correctly identify that this property can be used for parking, just not the short-term rental parking that they were advertising for. So if you're unable to find for $1,000, as you're alluding to, we would at the very least like $250 per day for the fact that the use at that property, what they were using it for, was prohibited.
But again, that's not proving to me it's irrevocable or reversible. You're allowing a cure period. So if I'm not going to be assessing, because my job under Chapter 162 is if it's irrevocable or irreversible or a repeat violation, I can find that day. I don't have the same level of evidence here. I don't find that it's irrevocable or reversible. You said that the property is now in compliance.
Right.
So if the property is now in compliance, it means that there was the ability to comply, which means that you can have a cure period. And then I've heard testimony here today saying the property is compliant. And so
Yes.
I don't have the ability under Chapter 162 or your code to assess a fine when there's a compliant property.
Understood.
Now, I haven't heard from the respondent yet, and they will be under oath, and so maybe I can inquire and ask some of those questions to find out if there was paid parking. But
Thank you.
as it stands right now, I don't have the evidence to support what you're requesting.
Got it. Yes, ma'am. Thank you.
Is there anyone here on behalf of the respondent? If you could please come up, state your name for the record and your affiliation with the corporation.
Hi, my name is Perrine Fure. I am the property manager with Brixmore Property Group.
And can you spell your last name for me?
F-U-R-E-T.
Okay, and Ms. Fury, you said you're the property manager?
Correct.
Okay. Before you begin, I'll let you speak kind of to what you, to the violation, but I do have a question. Did you see a picture of a vehicle that was parked in that lot that Mr. Rivera put on the screen, the black truck?
Yes, I did see the vehicle picture.
Do you have any knowledge if that black truck paid to park in your lot?
I am not sure.
Okay. Okay, thank you. And what would you like to, and just recall, I don't usually say this, but just recall that you're under oath.
Right.
Okay, and Ms. Fury, what would you like to say in defense of the violation?
Yeah, so as far as the violation, I know it was dated the 28th of July. We received it on the 4th, and as soon as the violation was received, we sent it over. We stopped all parking enforcement at that property. We were not aware of the requirement for conditional permit applications. So with that, we decided to reach out to the parking provider to stop operations, and we will work towards, applying if that's something that the property owner would like to continue with. But for the time being, as of the 4th, there is no paid parking enforcement at the property. I have provided pictures to you over email, and then I stopped by this morning at the property. There is no paid parking signage or parking enforcement.
Okay, and when I was reviewing the pictures, it looked like there was a third party called Metropolis Parking that was using that lot. Is that correct?
Correct. They were the parking enforcement patrol provider.
Okay, and so you no longer are doing business with them at that location?
Not currently.
Okay. Okay. Anything else, Ms. Fury, that you'd like me to know?
As far as the process goes, knowing that we are in compliance, we have sent over images. We will see if we decide to move forward with applying for a commercial or conditional use permit. Is there anything that you would like as the property manager and owner?
That's going to be between you and the city and that application process. So from my point of view, I don't need any information on that. But if you are looking towards that, you may want to meet with the city, the requisite people that can point you in the right direction.
Perfect. Thank you very much.
Madam Special Magistrate, could we ask a question?
Absolutely.
Could you please tell us what the arrangement was between you and the third-party vendor that you contracted with?
As far as the
Financial arrangement?
Financial?
Yes, please.
So with the provider, it was 30% of the sales were going to the Metropolis parking, and then 70% of sales were going to BRE Mariner Dolphin Village LLC.
And did you get a final accounting before you ended the contract of what funds were paid?
As far as that time period, I do not have a monetary amount that was provided for the duration.
So you do know that there was parking that was being paid for?
Correct.
Okay, thank you.
Okay. Anything else from the city?
No, ma'am.
No, ma'am.
Okay. All right, I am going to find that the property is in violation of the stated code sections. I am not going to find that it is irreversible or irrevocable, as the testimony here today has demonstrated that the property is now in compliance. Ms. Rivera, I don't remember, $330 in administrative?
Yes, ma'am.
Okay, so I will assess the $330 in reasonable administrative costs of the city and add the language with regarding to the recording or releasing liens if required. I will say this to the property management company. This is a first violation. So if there's a second violation, it could attach a daily running fine of up to $500 a day. Or if the city can prove that it's irrevocable or reversible, a one-time fine of $5,000. So just understanding if you are going to use the property in this nature, like you said, the conditional use in the proper channels, please do so. Other than that, I will get you in order. Just make sure I have your information on this case. Okay. And thank you very much. Moving on, there are no repeat violations, nothing under cases complied. Moving on to agenda item 7A, case number 2026-0104 and 2026-0201. I have this as a motion for reconsideration, and before we begin, I do have a question. What gives me, sitting as special magistrate, the authority to reconsider one of my orders?
There doesn't seem to be anything necessarily in the code, so therefore we resort to rules of court. So there needs to be some method to make corrections. If there's errors, mistakes, something's overlooked, there has to be some way to remedy that.
Okay, and I can understand that. The only reason that I ask is because, to your point, Mr. Shoshone, there is nothing in the city's code that provides for a rehearing. So what are my criteria that I'm bound by in order to determine whether or not a rehearing is necessary in this context?
It would be the same general rules that would apply to a court of law. And
even though this is an administrative proceeding.
So, again, yes.
And it is a quasi-judicial proceeding.
Correct. So a mistake of fact, mistake of law, and that is what we are looking at here today.
Okay, and then prior to proceeding on this, I do believe Mr. Cezanne does have counsel here. Ms. Gagnon, do you have any response to my ability or authority to hear a motion for reconsideration?
Yes, I'm
okay. If you could please come up and respond to the city's proposition.
Thank you.
And I'm not saying I will or will not rehear it. I just want to hear the arguments for and against it before I take a ruling on one way or the other.
Thank you. So again, my name's Alyssa Gagnon, an attorney at Weber, Crabb & Wien. I want to keep the position fairly simple. I don't believe that you need to reach the merits of the motion for reconsideration. The city's own code provides a procedure for review of a final order entered by yourself. Sections 22-281 and 22-288E, and I believe that's the municipal codification of Florida Statute 16211. Direct an aggrieved party to seek review in a court of competent jurisdiction. It's very, very clear that this is the only route to relief, and it expressly says that this applies to private parties as equally as it does to the city itself. The order itself as well, the final order that was signed, also directs the city to appeal within 30 days to a court of competent jurisdiction. I would implore you to apply the statute as written.
Okay, and what about to the point that Ms. Shoshone has risen, that when the code is silent on that we look to the rules of court in order to determine whether or not that there is the right to a motion for reconsideration.
Right, I don't have that case law. She provides nothing in the motion for reconsideration that gives the authority for it. I do have 2 case citations that I can give to you. I'm sorry I didn't print out the cases that show that if you want to appeal a final order, the only route is through a court of competent jurisdiction, and that is what the plain language of both the St. Pete City Beach Code says, as well as Florida Statute 16211.
Okay, and then what about, and I'll take argument from respondent first, and then I'm going to defer back to the city. The rules of appellate procedure and their application regarding reconsideration prior to taking an appeal. Can you
rephrase your question? I'm sorry.
The rules of appellate procedure require, and the rules of court require a reconsideration motion to be taken in the Florida, if what Ms. Shoshone says is correct, that the rules of court apply, and we're looking underneath the Florida Rules of Civil Procedure, in order to take an appeal under the Florida Rules of Appellate Procedure, the underlying case must have a reconsideration motion that's been denied to preserve your right to appeal. Do you have anything that would support your position that that's not required in this type of an administrative hearing?
I do not have anything supporting that position, just the simple fact that I do not think that this should be able to be heard today.
Okay. Anything, Ms. Shoshone, further?
Yes. So we are trying to avoid an appeal. It is obviously less costly for both the city, and it's less costly for Ms. Gagnon's attorney, or Ms. Gagnon's client. So again, this is just a simple overlooking of a document and is easily reviewed and can be corrected if magistrate sees fit. It is just a much simpler and better process than rushing straight into an appeal that's going to cost everybody a lot of money.
Okay, and I see in the agenda report the motion for reconsideration, but I also see Exhibit A attached to it is the final order from 2026, or 2023, even though it says it's from 2026.
So there were 2 orders, and apparently at the hearing, one was looked at, and Madam Magistrate determined that it did not apply because it mentioned that it didn't say anything about parking. It briefly mentioned parking, but did not find a violation then. The thing is, there was another order that was issued that did find a violation of parking, and we're not here to rehash the merits of the details of the case, simply that was this a repeat violation or wasn't it a repeat violation? And there was an order that would indicate that it was a repeat violation.
And that was not presented at the underlying case.
So whether it was presented or the other one was presented, I don't know exactly what happened. I believe there was a notebook that had former orders in it, and
I was only presented with a single order at that hearing.
Okay.
And it did not mention parking, which is why my order found that there was not a repeat violation. So your argument here is that there was another order that existed, it just wasn't the order that was presented by the city.
The order did mention parking, but it mentioned that the parking then at that particular time was in compliance, so it didn't go further into addressing the parking problem. It was there was a previous order that did find a violation.
And that order was not presented at that hearing. I'm not ready to. I was going to explain why. Right, I'm not ready to. That's the basis for the motion for reconsideration. I'm not prepared to even address the motion for reconsideration at this point. I don't. I need more than we just rely on the rules of court. That I can hear a motion for reconsideration. And the reason why is my understanding of the way that reconsideration works is in an administrative hearing, especially code enforcement capacity, unless it's specifically requested or specifically part of the code enforcement board's rules of procedure or set forth as an allowance or an authorization of the special magistrate, reconsideration is not usually, it's not had. And that reconsideration does not toll the time to take an appeal of a final administrative order regardless. That would be the Palm Bay case. So I don't want to put the city out, although I think this was, I don't have the order before me that I actually issued. So
These were a combined case, so the orders.
I understand that.
Okay.
I'm saying I don't have, what is attached to your motion for reconsideration is not my final administrative order that I gave at the last hearing.
No, that was the one that should have been looked at.
Right, so my question is, what was the date of the last hearing? Because I believe I got the orders out the same.
It was last month.
Okay, so then underneath the rules of appellate procedure, you guys have the city has 3 days to take a formal appeal, and even if I hear a motion for reconsideration, that does not toll the time for an appeal. I don't want to put the city in a position, but I also don't believe that I have the authority to hear and rule on the motion for reconsideration. So what I am going to do, so that I do not unduly prejudice the parties, and because this is a court of equity in some circumstance, I am going to allow the city to make its point on the motion for reconsideration. I am going to warn the city that do your due diligence, but there is very good case law out there that says that if you don't take an appeal within the 30 days, you lose your ability regardless of the fact that you've moved for reconsideration. I will hear the motion today, and then I would like the parties, I'll make a ruling at the end as to what I expect, but a kind of foreshadowing. I'd like the parties to get me a brief legal synopsis on I have the ability to even hear the motion for reconsideration. I will rule on that first, and ultimately rule on the motion for reconsideration if it's allowed to be heard. But I want to hear it here today so that I don't prejudice the city in any way, shape, or form by not at least considering it. Does that make sense, or did I jumble that?
Yeah, I'm lost here. First, it sounds like you're saying you don't think you have the ability to do that.
I don't believe I do, and I don't have any law except for you arguing we use the rules of court, but I don't have anything that says we use the rules of court. And I am very familiar with Chapter 162 and some of the case law behind it that says I don't have the ability without a legislative delegation of power from the city commission that I can hear rehearings, because that's what Chapter 162 specifically gives the local governing body the ability to delegate me authority to hear code enforcement cases.
Well, this isn't exactly, we're not really asking for a rehearing. We're asking for a reconsideration and not to rehear the whole thing, just to correct. If there was a typographical error, I'm not sure how we would even bring that forward then.
Well, that's a Scribner's error. That can be done without a hearing, and there is support for that. So
and we're not asking for a hearing here. We're just asking you to take judicial notice of an order that you had previously issued that was overlooked at the last hearing.
And I understand that, and if you look at the rules of Florida civil procedure, they consider motions for rehearing and reconsideration in the same breath, and the case law is pretty specific about that. Based on what you've given me, if this is, and I will defer to the city, I can either take it under advisement and you can give me your brief on whether or not I have the authority to do it, or I'm going to go based on the case law that I've been presented here today and the statutory authority that says I don't have the ability. Because
well, it doesn't sound like we have time to give you a brief if we have to appeal within 3 days.
And I understand that.
So
again, there's no I understand that, Ms. Shoshone, and I do appreciate that you're in a difficult position. But there's no rules underneath. There's no delegated authority from the commission that gives me the power to do it, and I don't want to take the power to do something I am not allowed to do.
All right.
So I can either allow you to brief that issue, take the testimony, or take the motion for reconsideration, hear it today, suspend ruling on it until I receive the briefings from the parties. If the briefings state, and I rule on that says I can hear the motion for reconsideration, I will get an order out that says yes, I can hear it, and what my order on that is. If the law says I can't reconsider it because it's not a delegated authority, then I will say I cannot hear the motion for reconsideration. But at least we've already had argument on it, and I can make that ruling without having another hearing. We can do that ex parte.
I don't think that there's time for that. If you're saying that this does not toll our time for an appeal, and then I've got only 3 days to appeal, There's no time to be briefing and having you look at briefs and to make rulings.
And
We've got to move forward.
I
So
agree, Ms. Shoshone, but I'm,
just deny or determine you don't have the authority.
well, okay, then I'm happy to do so. Then, based on the arguments that have been presented here today, I find it credible that the case law that has been presented, you said you had a couple of cases?
Yes, and I can provide those to you, yes.
If you could please provide me those case citations?
Correct, yes. Two cases, would you like me to quote them or just the citation?
Yes, please.
Okay, the quote, section 16211 provides that an aggrieved party may appeal a final administrative order of an enforcement board to the circuit court, and that such appeal shall be limited to appellate review of the record created before the enforcement court. The plain reading of that section clearly provides for plenary appeal to circuit court as a matter of right. That is from MGM of West Florida, LLC, v. Manatee County, and the citation 406 SO3D 351. The pin site is 353.
And that's second DCA?
Yes, ma'am.
And what year?
2025. And I have another case as well.
Okay.
Review of a code enforcement board's order is by appeal to the circuit court. And that is Sarasota County v. Bow, B-O-W, Point on Gulf Condominium Developers, LLC. And that is 974 SO2D 431, pin site 432, footnote 2. And the year is 2007.
Okay. And Ms. Shoshone, aside from your reliance on just that we rely on the rules of court, do you happen to have any case citation or anything that you would be able to give me here today?
No, this has always just been done administratively. We've never had this problem before. I've never had this problem before in 30 years of representing cities. So, you know, we always give either a code enforcement board or a magistrate an opportunity to correct errors before we go running off to court with an appeal.
And in those jurisdictions, have you had the ability to do so within the jurisdiction's code?
Some of them particularly mention it. Most of them do not, like this one.
Okay. Okay. Based on the evidence, or not the evidence, but based on the argument presented here today and not having anything in the city's code that gives me the authority and understanding the Palm Bay case as well as the two cases represented by Respondents' Counsel, I do not believe I have the authority to hear a motion for reconsideration of the order that was previously presented. So I'm going to deny the motion for reconsideration. And I will get an order to that effect.
Thank you, Special Magistrate.
Thank you, Ms. Gagnon.
Thank you.
Okay, moving on to agenda item 8A, case number 20240172, City of St. Pete Beach versus NXT Acquisitions Corp.
Thank you, Madam Magistrate. Stephen Rivera, City of St. Pete Beach Code Enforcement. This is a lien reduction request application for NXT Acquisitions. This, let's see here, case number was 20240172. The total amount for the liens, the total amount lien recorded for fines and administrative fee totaled out to $164,900. They're requesting that this be reduced to $5,000. The property does have their permits. They are compliant at the present time. Put this on the overhead for you here. So here is the lien reduction application. Last page here.
This is Francis' instruction.
Signatures, notary, the notary. This is all part of the limited power of attorney. Signature back here. And this is the receipt for the taxes being paid. It's the city's position that we would request that the full amount be paid. I do believe there is a representative here from NXT Acquisitions who can come forward.
Anyone from NXT Acquisitions here in support of their petition for a reduction in lien request? If you could please state your name and affiliation with the property owner for the record.
Yes, ma'am. My name is Kaylee Arn, and I am Director of Operations for the company.
Okay, and Ms. Arn, I have seen you before me previously. Can you explain to me, I see that it says it's beyond your control. However, there were hearings where nobody from NXT showed up. Notices were sent, nothing was done. So can you explain to me why you said that circumstances are out of your control?
Yes, ma'am. So as far as the original hearing that resulted in the lien itself being issued, we actually had someone that was supposed to be here as part of like our permit coordination team that we had hired to take care of this. I'm in Miami. I'm based in Miami. I literally drove up here this morning for this hearing, and I always drive up for the hearings when you've seen me in the past. So this person's actually local, and they didn't come to that specific hearing at that point. We have gone through 3 different general contractors throughout this whole process. We've gone through probably half a dozen, maybe even closer to a dozen different plan review changes throughout the time. Engineers, you know, every time you get plan review, it takes 3 to 4 weeks minimum to get all that back again. So just time just continued and continued, and with those time delays also resulted in specific GCs no longer being able to do the job, just be changing the circumstances, having to go find another GC to attach and then kind of continue to move forward. At this point, the request is that there is a significant reduction in the fines because, as you mentioned earlier, the point of code enforcement is for compliance. It's not for punitive damages. However, I do recognize that the city has put in time and energy into this case, so that's why we recommend the $5,000 reduction, so that there's obviously some payment towards those efforts as well, but not so much so that it's going to cause significant financial hardship to the homeowner.
Okay, so then explain to me, the underlying violation was for failure to secure permits. So it was for doing unpermitted work to begin with. So while I can understand your plight, not being able to get contractors, the fact of the matter is that the first violation was issued because there was work being done on the property without a permit.
Correct. To my knowledge, and at this point, like, I wasn't involved in this whole thing, is that there was a property construction manager that was helping. That person is no longer on the team, hasn't been working for quite some time at this point, and there was somewhere miscommunication. I believe he even spoke with Mr. Rivera, and there was a little bit of kind of back and forth that occurred. So that just, unfortunately, is just something that the homeowners out of city, and just kind of allowing employees to run things and hopefully do what he's paying them to do, which is go through the proper steps and, you know, take care of these items.
Okay. Anything else that you'd like me to know, Ms. Arm?
I mean, we at this point, we have the permits issued. We have a general contractor that we're working with. Currently, we're waiting on some materials to be delivered so that we can, you know, continue construction and, you know, hopefully get it to a point that's resolved.
Okay, so and according to Mr. Rivera, you said the permits have been issued, correct?
Yes.
Okay, but the project is not complete. All right, thank you, Ms. Arn, I appreciate it. Anything further from the city?
No, ma'am.
Okay. So sitting in my capacity, the city's code says that I need to take into consideration when issuing the lien or the fines, the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator. Mr. Rivera, NXT Acquisitions is a name that I believe I've written several orders on. Did they have any previous violations?
It primarily was the work without a permit. It was back in the end of 23, I believe, is where it started. There was some overgrown grass violations.
That was a different property or the same property?
It was the same property. I think it was when they were kind of going through the motions of changing hands of who was responsible. This all stemmed originally from a complaint. The neighbor next door complained about the condition of the property. Upon inspection is when we found out that there was a permit application to enclose a small portion of the house. At inspection, we realized the whole inside was gutted. It was way beyond the scope of the permit at the time. And then there was an issue with the permits expiring, which I believe is when it came back.
Yeah, I recall that. Okay. Thank you very much, Mr. Rivera. And Ms. Arndt, anything in response to that you'd like to address before I make my ruling on this?
I mean, we just need to be able to get this construction done and hopefully have the money to be able to finish it. So this fine is beyond anything that's reasonable. I did receive a email this morning at approximately 7:15 in the morning from the city regarding some level of settlement agreement that I had requested probably half a dozen times, that no one ever said that was a possibility. They said, no, you have to come to special magistrate. They did provide me, whoever this is, provide me an itemized breakdown, which at this point I believe to be a little bit ridiculous. So that's kind of like my last things.
Okay. All right. I appreciate you coming here today, Ms. Arndt. There's been a lot with this property, but you are correct. It shouldn't be punitive. Your company is trying to work to resolve the issue. Permit has been secured. You've testified here under oath that you are working towards completion. I am going to grant the lien reduction request, so I'm not going to grant it to the $6,000. I am going to reduce it to, by 30%. So I'm going to take 30% off of that and reduce it to $49,470 plus the $325 in reasonable administrative costs of the city. And I say that with this, and it's the same thing I've said to other people that have come before me. You buy property within the jurisdictional boundaries of a city, you are required to comply with the city's code. Violations of non-permitting for Florida building code issues, you could have avoided all of this if you got a permit to begin with. I'm not here to rehash the case, but I am here to take into the gravity of the violation. There are 2 hurricanes that happened. These are post-hurricane repairs or renovations. They were done without a permit. They were done interiorly, and based on the testimony here and previously and the changing of hands, I don't find it credible that efforts were made that this was just a mistake, especially since the permit that was given was expired, et cetera. So given the nature of the violation and the gravity of the violation, the actions taken by the violator to correct the violation and previous violations committed by the violator, I think a 30% discount is sufficient enough. It is taking into account your credible testimony here today, and that is going to be that I will allow 30 days to pay the reduction. If it's not paid within 30 days from the date of my order, it will revert back to the full amount.
Am I able to say anything else?
You certainly can. I don't know that it will change my ruling.
I mean, city, they provided to me a settlement that was approximately $44,000.
I have nothing to do with the settlement. I don't even know if they have the authority to settle code enforcement liens without my authority underneath their code. That's between you and the city.
Yeah, they specifically told me that it wasn't possible. So the fact that they sent this to me literally this morning at 7 a.m. I'm not exactly sure what the situation was.
I have no knowledge of that, and that's I'm not even taking that into the calculus of the lien reduction. I'm only allowed to look at the 3 things for imposition of a lien in order to reduce the lien under the city's code. So that is what I am bound by, and I have looked at that. I have said on the record the reasons for it. I am reducing it by 30%. So again, you wouldn't be here if you know, NXT had followed the laws to begin with, and if it wasn't such a long and drawn out process. So. With that being said, again, I will get you an order to that effect, and you'll have 30 days to pay the reduction, or it will revert back to the full 164.
What is the total?
$49,470, and then the $325 in reasonable administrative fees.
470 and then 300.
25.
Okay.
And like I said, I'll get you a written order that, I believe I have your email address from before, but just make sure it's on that list.
Thank you. Yes.
All right, thank you, Ms. Arnn. I appreciate your time here today. Okay, I believe that is the last thing we have on the agenda for today.
It is, but I have a request, please.
Yes.
Previously, we were able to email either you or your administrative assistant to have corrections made to the orders. If we have orders, specifically the city clerk would email you. We try to stay away from communicating with you as code enforcement.
Mm-hmm.
But if those orders have, whether it's Scrivener's errors or any other errors that we would like to have corrected, how do we communicate that to you, please?
So you can email, my paralegal no longer works at our firm.
Yes, ma'am.
Presently, my new paralegal does not start until Monday. So presently,
Okay.
you can email me.
Yes.
I will not be correcting substantive errors or what you perceive as substantive errors unless they do not comport with what was said on the record at the hearing.
Right.
Otherwise, that's, it's my ruling, it's my ruling.
Sure.
Scrivener's errors, I have no problems with,
Okay.
doing it. I will let you know the reason for those is I sit and I do all of the orders.
Mm-hmm.
I usually have a paralegal go over it and catch those, and here we are.
Yeah.
So
Okay.
I have been trying to do my best and put not a ton of time because, again, my time is money to the city.
Of course.
But I want to make sure that I get you the correct order.
Absolutely. And
So I do
the
appreciate
other,
that.
we appreciate that. And the other request is, could you please add to your orders the reasonable administrative costs of the city in the amount of whatever that amount is for the reasonable administrative costs, and the actual costs incurred in recording and or releasing a lien in this matter, please?
I can do those.
Thank you.
You want those on all orders and say
Yes.
if applicable, or do you want them on only the fine orders?
Orders where that information is
costs imposed. Okay.
applicable. Yes, please.
Yes, I can certainly do that.
Thank you.
Of course. Anything else, Mr. Dewar?
That's it.
All right.
Appreciate your help
You
and your
all
time.
Have a wonderful day. It is
You as well.
11:52.
Yeah. Thank you.